I'm joined here by the Minister of Justice and also the Minister of Rural Development and Land Reform, and also the Chair of the Advisory Panel on Land Reform. Well, today's event, Fifi, is just a second colloquium on the issue of land reform. And as you know, that land is quite a big topic as well in South Africa at this point in time. But let me not waste time and just get straight into it. Dr. Mahlati, thank you so much for making time to speak to us, as well as the honorable ministers. Just brief overview of today?
Well, thanks so much. Today is actually a very important day because it follows intense consultative processes from the last colloquium last year to various roundtables with different stakeholders on various topics. So today becomes very important, and we're very grateful with the attendance today, but most importantly, this day starts with the focus of land and justice, because when we address the constitutional issues, it becomes important for us to place, because that's what the Constitution does. It talks to all the issues of dispossession, restorative justice, dignity, and ensuring that there's just and fairness and equality. So Judge Jody Colloquium did a very good job of addressing that. But what was very important with his address as well was addressing the problem of a litigious society and total reliance on courts, and that it's important that the Land Reform Panel work addresses that and comes up with practical solutions that also ensure that at community family level there is what he refers to as mandatory mediation, such that by the time cases get to court, they would have dealt with a lot of issues, because he says in court we deal with lawyers. We don't actually deal with the people who have issues. What was important, though, is that the opening was by the minister in the presidency, Minister Nkosazana Dlamini Zuma, who assisted in taking us backwards as far as the historical issues around land and how we have progressed, and some of the complexities, and the role that the interministerial committee chaired by the deputy president is actually trying to fast-track the process.
Minister Mashiqana, I just want to ask you this question. Would you say that South Africa's land reform at this point in time is at a crossroads?
The land reform process in South Africa has never been at the crossroads, because we have a constitution that we celebrate the world over. All we should be saying, which the president has reminded us in the previous SONA and in the current SONA, is that we quicken our steps. While Parliament is dealing with the Section 25 of the Constitution, expropriation without compensation, we should do what government need to be doing with the modalities that we have at hand. We do not and never had a situation where we want to put our people on panic, but we should be seen to be responding to their calls when they are made, so that we separate reality from that which is not. We work together, as Dr. Mahlati had said. The panel does its work. The interministerial committee, which I am a member of, which is chaired by the Deputy President and Minister Dlamini Zuma, looks at all the departments that have something to do with land reform, from human settlements to provision of water to and sanitation and all. We work together under that under that interministerial commission, and we meet quite regularly. And we think we are making progress. We are not waiting for the parliamentary process, which we all equally applaud. But equally we applaud the openness of the colloquium, because there has been more than one that Dr. Mahlati had called. with the traditional leaders, with every other stakeholder, to make their views on how do we quicken our steps, how do we move together forward. That indeed the process has been slow, but therefore stakeholders have to come to the party.
Minister,
We are a constitutional democracy.
thank you, Minister. Minister Mashiqana, let me come to you. The law's side on this issue.
Well, you'd notice that the Commissioner this morning in her presentation also alluded to the various laws over and above Section 25 of the Constitution, including laws that are inherited from pre-democracy, such as the Expropriation Act of 1975, which is still part of our statute book. So part of what this exercise also needs to do is to unpack the entirety of the legislative regime as it stands that governs the administration of land, and to see to what extent it enables or impedes the objectives that are sought to be realized, together with unpacking the Section 25 provisions in terms of the various pillars of Section 25, even as it is undergoing a review. There are bills that are before Parliament which also touch on some of these topics, which I believe that this process will help inform as well. There has been the issue raised. Let me also mention that we have already introduced the concept at the Interministerial Committee of a land court bill, as opposed to the current land restitution court act, which confines itself to only one topic out of a series of legal aspects affecting the administration of land and dispute resolution in land matters. But also, so we're hoping at this colloquium to also give highlights of what we propose could be the key elements of such a new bill, and effectively a new court. But linked to that, as was mentioned earlier on by the chair, the issue of introducing less adversarial methods of dispute resolution that is outside of our court system, because the courts, by their very nature, tend to be adversarial. Just to indicate that as early as 2014, I unveiled a project called Court Annex Mediation. And we have been training mediators since. Recently, for example, end of last month, I unveiled the induction of 70 new mediators at the Department of Justice, who come from different backgrounds, different professions, in order to standardize and professionalize mediation in South Africa.